Hello, everybody, and welcome to today's Be Well talk. And we're going to be covering taking control of your legacy, estate planning. So I wanted to take an opportunity to introduce myself first. I'm moderating today and also covering a couple of the topics. My name is Eileen Schiller, and if we haven't met, I'm the manager of financial and workplace programs at Wellspring. So in that capacity, I am involved in our Money Matters program, our Returning to Work Support and Education program, Wellness at Work. I'm one of the leaders of our brain fog program, and I'm also involved in some of our peer support programming. So happy to be here today and thrilled to introduce today's presenter, Karen Slazak, who is a partner with Crow Soberman's tax group, and she leads the firm's estates and trust group, and lots of different specialties. She works with clients on most topics pertaining to their finances and estates, so covers things like tax minimization, will and probate planning, estate administration, insurance, and charitable giving. So the whole gamut of financial and tax topics. So again, thank you, Karen, for being here today to cover these very important issues. So I just want to start off with a little bit of housekeeping. So first of all, our disclaimers. So we're going to be covering a lot of things that get into the realm of tax and accounting and legal advice, but they are not intended to constitute any type of advice. We're really just providing you with very, very general summary information. It's always important if you're putting together a will or an estate plan or powers of attorney to get advice specific to your circumstances. So always a good idea to consult a legal or tax, accounting, or another professional advisor. In terms of your questions, Karen is happy to answer your questions at the end of the presentation, and you'll see the little Q&A section where you can put your questions and we will address them at the end. So what are we going to cover today? Lots. We're going to talk about the components of estate planning, why it's important to make a will and what should go into that will. I'm going to talk a little bit about putting charitable gifts in your will, as well as powers of attorney. And then we'll sum things up by just talking generally about taking control of your legacy. So on that note, I am going to turn things over to Karen.
Thank you, Eileen. It's lovely to be here today. And even though I can't see all the faces out there, I appreciate you tuning in as well to hear this. I've been involved in doing estate planning for many years. And one of the stories you always hear is if you fail to plan, you plan to fail. And if you fail to plan in the way we're going to go through about your estate planning, you really leave quite a mess for your family or friends or whoever has to pick up the pieces after you pass away. You will see on the screen that we listed out, 8 items here that we'll just touch on, which are part of an estate plan. It's more than just your will. And we'll say a little bit about each of them and why they're important to what you're trying to do. So let me start with the will, because that really is the key document. That's the really most powerful document typically in most estate plans. A lot of people don't really understand the way a will sets out the whole pattern of what the person who's going to manage your estate is going to do. You're going to name someone or a couple of people to be the executor, meaning the person in the driver's seat to manage your will. And they're charged with first taking an inventory of everything you owned at the time of your death. And maybe they'll call in what we call collect some of your assets, bank accounts, know what real estate you held. Do you have any more sophisticated investments like stocks, mutual funds, and so on? So that's always the first step, is understanding when you are in the role of an executor or someone comes to me, the accountant, is understanding what the person has at the time of death. And then there's a responsibility to pay off debts. That could be like credit cards, funeral bills, and also the big one, to pay off taxes. And finally, there's a plan to how the estate is going to be paid out, the disbursement of the estate. And that could be specific payments. We call those legatee payments. There could be amounts that get held in trust, and we'll talk about that a little further down. And money that's just, or assets just paid outright. So as you can see, it's a very powerful document that presents your wishes and the wishes that you want to have followed after you pass away. During your lifetime, the next most powerful document is your powers of attorney. And powers of attorney mean that you name someone to step in and manage your affairs when you cannot do that because either you're incapacitated or, there's been, say, a health issue and you're not able to do it for a short period of time. There's two types, and Eileen will go through them in more detail, but there's a power of attorney for property, meaning like money, assets, real estate, and a power of attorney that covers your health wishes. Next one down, tax planning needs also to be considered as you're drafting your will with a good lawyer and accountant. There are some items that you won't be able to incorporate if you don't have a will. And we'll touch on those later. We say, well, why do you need a will? But there are ways to save money for your estate. You can have an estate for up to 3 years that gets lower tax rates. You can save a significant amount of money through charitable giving. So incorporating tax planning into your will planning, estate planning is pretty critical, because otherwise you're just handing money over to the government that maybe doesn't need to be paid. Probate planning is another important thing we look at, but I always put tax planning before probate planning, because tax planning means you're saving tax on items that maybe could be anywhere from 26% tax up to 50% tax. Probate planning means you're saving probate fees when the will gets probated in front of a judge as the final will. And it's not insignificant. It's 1.5% of the value of all your assets passing through your estate. So we do look at whether there are simple techniques to avoid paying that probate fee, such as, again, using trusts or holding assets jointly or using corporations. Insurance is also a cornerstone in most estate plans, because you may have, you may be asset rich and cash poor. And I see this where maybe a family has a cottage or other real estate, and the family cottage, they don't want it sold after death. And yet there's a tax bill on the cottage. So one of the ways that may be cost effective is to have sufficient insurance in place to provide cash to pay for taxes. Insurance can also be used effectively as a way to provide for charitable gifts and reduce, again, the tax on death. By designations, we mentioned here designations of life insurance policies, a RIF or RSP, a TFSA. Those are also excellent ways to avoid probate, because we won't have those plans paying out funds through your estate and requiring that levying of the 1.5% probate fee. But there are some potential traps if too much money jumps the estate and there's not enough left behind to properly pay for taxes on your final tax return. And finally, charitable giving, which will also be touched on by Eileen. I like people to remember that while you may think that you have named, let's say, 3 of your children as beneficiaries, there's always a 4th one at the table, and that's the CRA. The CRA is always a beneficiary who's going to take a slice of your estate before your kids get any of it. And through some very smart charitable giving, we can actually cut down what the CRA gets, and you can direct it to the charities of your choice, who are perhaps more in line with how you'd like to have your money going after you pass away. And a lot of people are happy not to fund the CRA. Okay, so the next one is remembering, as we review your estate plan, you must remember that an estate plan is not a static document, as in one will and it lasts forever. It's not a static item. It's an ongoing, evolving plan that needs to be at least reviewed on a regular basis as your life changes. So my typical rules of thumb is, as a minimum, you're looking at it every 5 years. And definitely you need to reconsider it if there's different life events happening. So of course, if you're separated, if you're divorced, you need to change that. You need to change wills, and you need to reconsider powers of attorney and gifts, because of course you don't want things to go to your ex. If there's new assets in your life, such as happens all the time, people like to get a Florida property, an Arizona property. We want to set it up so the US won't tax those properties when you die. So there's new assets, new planning. Maybe there's additions to your family, grandchildren. Maybe you've adopted a child. There's, again, a need to consider what's happening within the family. Or maybe, God forbid, there's a health issue with one of your beneficiaries, and you need to set things up to protect them, so that in the event that as you want to turn over money later on, you want to make sure that they're in the best of health, or have people protecting what they're going to inherit. I couldn't, of course, emphasize enough, tax rules change, legal changes also happen on probate and so on. We went through a significant change in 2016, where they changed, the CRA changed how estates are taxed and how trusts are taxed, which meant a complete revision to quite a number of estate plans. So you need to keep abreast of whether there, whether there are changes like this. And that's why I say is, okay, the best thing you can do is on a reasonable basis, check in with an accountant and say, is this still current? Does this still make sense? And I think bottom line is, at the end of the day, you want to make sure your will represents your interests of what you want to happen. And, whether this is going to make sense for your beneficiaries as well. Next slide, please. Oh, that part, okay. Sorry, my fault. I got my notes here too. Why make a will? Maybe it's more the other way. Why not make a will? As we sort of touched on, a will is ultimately your best way of expressing the wishes that you wish to be carried out when you're no longer here. And it's not necessarily that you want to rule from the grave, but you do want some direction about how you'd like to see your funds ultimately dispersed. So if you do not have a will, then the government comes in and has a forced heirship regime. It's not as bad if you have a spouse. The assets will pass along to a spouse, and maybe that's what you wanted anyway. But if you have a spouse and minor children, part of your estate will not pass to your spouse. It will be paid over to a guardian or the public guardian and trustee to be held until your children are 18. And then they come into those, effectively turn into cash. They'll come into that cash when they're 18. So for some people, maybe that's not necessarily a big deal. And for others, it could be a very significant number to be paid to an 18-year-old. So it's a pretty significant consequence. And if there's no spouse and children, the assets would go first to your parents. And if there are no living parents, to your siblings. So you can see if that's not where you were intending your money to, your assets, your hard-earned, accumulation of what you've done, if that's not what you're intending, assets could go wherever you want it. Wherever you did not want. And there's no tax planning there. There's no probate planning going on. There's no charitable giving going on. It's just, this is where it'll go after the taxes are paid. The other one that's difficult too is if you have minor children or disabled individuals, they won't be protected in the way you might have done with a trust that says, I don't want this paid out immediately to my child. I want it paid out maybe when they're 25 and 30 and 35, which is not uncommon. We stagger the distributions to a time when the child is a little more mature. If you don't have a will in place, as I say, it's just going to be held till they're 18, and then that's it. They're going to come into those funds. So it does put an incredible burden on a family to deal with an estate without a will. And application can be made for someone to act as a trustee, but they're still acting without a proper document to know what you wanted. And next slide. Our will checklist. Sorry, hold on a second. Okay, just need a quick drink. So I outlined a little bit about the structure of a will, but let's go down again some of the items that you need to think about in advance of meeting with your lawyer and meeting with your tax accountant, because we'll be asking these same items. And the first one is that word there, executor. Again, it's like, who do you think is the most appropriate person to run your estate after you pass away? Is it your spouse? Sometimes people just think I'll do it with my spouse, which is simple. And the question will be is, do they have the appropriate financial and or business acumen to manage the funds and work with the accountant or lawyer? Is it a complicated estate? If not, maybe that's a good way to go. If it's an estate with a business in it, a lot of real estate, a lot of unusual items, a lot of times people will say, well, I love my spouse, but maybe I'll name my spouse and my business partner or someone else. So the idea is to consider what skills the executor has and what are they willing to do. The other part that can be a little tricky is naming an alternative. If you just name one or two executors, you typically have to consider, what if something happens to one of them? What if both you and your spouse, gosh forbid, got into a car accident and died together? Who's going to take over? You need an alternative executor. And that can be a little tough to think about as well as to who would be most appropriate to do that. Whoever's named in your will should know that you've and agree to being the executor. They're not obligated to do the role. If when the time comes, they don't feel they can do it, they can resign the appointment, and then it will fall upon the alternative executor. And if there is no alternative named, it would go to the court to appoint an executor. So it has to be remembered that often sitting down with your executor, explaining would they be willing to do this and explaining what you're planning to do in your will is actually very, very good to do. And even further, when your children are of a later age, I know a lot of people feel very uncomfortable telling their children about the wills and what's involved, but it can be a wonderful exercise for them to understand what you're intending. Kids will assume that, oh, it's going to be the cottage 1 and 2 and 3 to all 3 kids. But what if you're feeling like one of the children, because they're living in the States, really shouldn't have the cottage because there'll be tax issues? Well, you don't hurt feelings that last after you pass away. You're not here to see it, but I see it. And the kids get upset, the kids don't get along because of it. So telling them in advance about what's in your will is really something that's a worthwhile exercise. And often doing it with a lawyer, doing with an accountant is, I think, a great way to do it, and we can answer any questions about it. I also want to touch on the fact that the residency of the executor, tax residency, is important to remember. If you're naming people that are resident here in Canada, and we tax in Canada based on residency, not citizenship, but residency, meaning you live here, you got a house here, you got a job or family and so on here, that's a Canadian resident. And then your estate will be a Canadian resident estate. But if your two children are in the States and you name them as your executors, you're going to pull this estate into US taxation, as well as possibly Canadian, and create a very complicated tax mess. So you do need to pay attention to whether your children are living in Canada or not, and try to avoid, actually we try to avoid naming people that are not residents of Canada. For beneficiaries, that's the other side. You do have to think about who ultimately is going to be inheriting. And as I said a moment ago, for minor children, usually there are trusts put in place. And what's a trust? Well, trust is like a minor version of the will. Instead of the word executor, a person named a trustee manages, holds what's being left for the minor child. As I say, they hold it effectively in the name of the trust for Karen Slazak's children. Whatever's in that trust is invested in a prudent way. The income may or may not be paid out during the child's lifetime. And then later on, when they reach certain milestones, then the funds can be paid out. And all of those conditions are also spelled out in the will. So whoever's the trustee has to follow the instructions in the will. The key is with the minor, you want the money managed well while they are too young to do that themselves, and that they're inheriting it at an appropriate time. We also have special trusts for disabled beneficiaries, because we know that people that may have mental or physical disabilities will not be able to properly manage funds, most likely. Some are, but many are not. So here is one that the tax department has provided us with, a trust that gets lower tax rates, and that's a qualifying disability trust. Special language needs to be put in the will to create one of these. But the nice part is that, assets can pour into one of these trusts for the disabled person and be taxed at lower rates before they're paid out. And then, as we were just touching on, beneficiaries, you don't want them as your executor, but you even have to pay attention. How's it going to work if they are your beneficiaries of the estate, your children in the US? Doesn't mean you have to cut them out. It just means that there'll be a little bit more complicated tax filings. So again, just get good advice. But while you're doing anything or before any payments are made, that's really the best thing I could say there. Your will checklist also, while your children are younger, or you have somebody that's involved who's disabled, who's a guardian for your children, can be a very, very difficult exercise. I will admit it was one of the most difficult things I had to figure out. So, it happens to the best of us. And I think it's something not to take lightly in deciding who might be a guardian. And a guardian, just like an executor, is not obligated to take on the role when the time comes. But most, if you've told them in advance, most will certainly do it. So working down the list here, plans for assets and property inside, outside Canada. What I mean by that was you need to think about, are you just leaving your estate where everything can be turned to cash and then distributed? Or there's times where we specifically say, we want this property like a cottage, this property like shares of a company. We want different things to happen, like them passing out what we call in specie or in kind. So that might be spelled out in the will. And you do need to think about not only Canadian assets, but assets worldwide. How are you dealing with assets in another country? It's not uncommon that if you have Arizona property or Florida property, that you get a separate will done in that state so that it's easier to deal with that property after your death. And I don't mean it to be last, I say last but not least, charitable gifts are a large part of a number of wills that I do, because charitable gifts in a will get preferential treatment when you die. So a gift that's specified in a will is often larger. Maybe it's a specific amount. Maybe it is a portion of the overall final balance. We call it the residue. And it'll create a tax deduction that we can use on the final return or the return for the year before you die, or up to 5 estate returns. So there's a lot of flexibility to use that charitable gift, which is often a larger gift, and on which returns we're going to use it. So, and I'll probably crossed over. I think Eileen's going to touch on that again, but I just wanted to raise that as well. I think it's yours, Eileen.
Yes, thank you. Yep. So I want to talk a little bit about, making a charitable gift in your will. I'm going to echo Karen's very important points. So it's also called planned giving. And it's really a great way to leave a lasting legacy. It allows you to leave a gift in your will to support charitable causes that you feel passionate about, and a lot of different ways that it can be done. You can leave money, you can leave other property like securities, you can leave a specific amount, or you can leave a percentage of your estate. So again, different ways it could be done. As Karen said, there are tax advantages. So if it has that important, goal of lowering taxes, that's great. And as was pointed out, it's ideal if less money heads its way to CRA than to your beneficiaries. So again, a really important tool. I want to talk a little bit about powers of attorney. So as you see on the screen, it's a legal document. And what you're doing in your power of attorney is you're giving someone you trust, and that's a very important thing to emphasize, it's somebody you trust, the right to make certain decisions for you if you reach a point where you're just unable to make those decisions on your own. So if you think of a will as a way to express your wishes when you pass away, powers of attorney are about, your wishes and decision-making while you're alive. And therefore, powers of attorney do end when you pass away. So there are two types of powers of attorney. The first one is powers of attorney for personal care. So that covers things related to medical treatment and other aspects of healthcare. It might be things like housing, your meals, your clothing, that type of thing. And the important thing with a power of attorney for personal care is it only takes effect when you become incapable of making your own decisions about your personal care. So that's the first one, personal care. The other type of power of attorney is a power of attorney for property. And that's where you're appointing someone to make financial decisions for you. And so again, that's things like doing your banking, paying your bills, managing your investments, maintaining your home, selling your home, those type of financial decisions. With a standard power of attorney, it's going to take effect as soon as you sign it. So if you don't want that type of power of attorney for property, you can limit it, and you can limit it in any way you want, but people will limit it so that it only takes effect when you become incapable of managing your financial affairs. So again, it's the type of thing, because there are these different components, that you would want to get legal advice about. In a power of attorney for personal care, one thing I want to mention that some people like to do is they use it also as a vehicle to express their wishes for advanced care planning. So that allows you to make, sort of some healthcare decisions while you're mentally capable. And they would pertain to how you wish to be cared for in the future if you became unable to make decisions. So, perhaps somebody wants to express the wish in their advanced care directive that they want to stay in their home as long as possible, or that they don't want extraordinary life support measures, that type of thing. So very, very important things to consider. If you're interested in getting, again, some very general information about powers of attorney, the Ontario government website does have a very good guide, and they do have power of attorney forms that you can use. Again, you could use them as a sort of basic version and then have a lawyer take a look at them. Pro Bono Ontario has a legal advice hotline. Again, if you want to take a stab at doing one on your own before having a lawyer take a look at it, Steps to Justice has this pathway that takes you through the different components of powers of attorney. And then if you don't have, a lawyer to help you with your will or your power of attorney, there's nobody you can speak to sort of get a referral. The Law Society of Ontario does have their own lawyer referral service that you can contact. So again, you can take a screenshot or a picture of the slide so that you can access those resources. So, the bottom line in conclusion, estate planning is your opportunity to take control of your legacy. A proactive estate plan gives you control over your decisions about your family, your children, your assets, your healthcare. And, as was pointed out, it makes things easier for your loved ones. And most important, it helps ensure that your wishes are carried out. And your legacy lives on. In terms of legacy planning, one thing sort of outside the realm of traditional estate planning that you may want to look into is where you create what's called an ethical will, or it's just called legacy planning. And it's an opportunity for you to sort of capture, preserve, and transmit your values, your life lessons, your memories, that type of thing. It's not a legal document. It's just a personal document you create to communicate, again, your experiences, maybe special memories and special life lessons to your family. So just something to think about, on the non-legal side. If a legacy gift or planned giving, leaving a gift to Wellspring is something, that, appeals to you and you'd like to explore it a little bit further, please feel free to contact Anna Santos. All of her contact information is on the slide. She's Wellspring's community giving manager. And now your questions. So I'm just going to see there's one in the chat. Oh, yep. So somebody wants, I'm just going to go back to the slide with the resources. So feel free to take a look at that. Karen, somebody is asking how much a basic will costs.
It's an interesting question. You can try to do it yourself with some of these downloadable wills or $29.95 will kits. I really don't think it's worth doing one of those unless it's the way Eileen said, using it as at least a guide and then taking it properly to a lawyer to do. Wills can run from a couple $100 up to several thousand, depending on the complexity of your situation. Do you have, as I said, do you have any special items like disabled beneficiaries? Do you have children out of the country? Do you have assets around the world? I mean, some of those could cost quite a bit. But a lot of people that have a lot more basic wills to do, I would probably think it's around $200 to do. And that's what I said. Now, why am I against the will kits? I mean, it sounds great for $30. It's just that in a lot of cases, it may not be fully properly executed. It may not have considered a number of items that we've gone over today, that at the end of the day, you pay $30 now, but then you have a big problem with the estate later. So I would typically say spend a few $100s more and meet with a lawyer that could do this. And if it's, yeah, if you're more involved, then I'm, you know, really don't be penny wise, pound foolish. You got to do something that's more involved, but it pays off. I mean, often I can suggest things that save a significant amount of tax for the estate.
And a related question, Karen, does a lawyer charge if you have to go back for changes in a couple of years, you know, re-review the estate plan, change a beneficiary, change in an asset? Would a lawyer charge for changes to the will?
Yes, they would, because it's a lawyer's going to charge based on their time, you know, unless they have sort of a flat rate for doing it. But we professionals like myself, accountants and lawyers, we do charge based on time spent. So to do it again, they're having to kind of refresh going through that document, making sure now they've asked you the right questions about what's going on and changes in your life. If it's as simple as, you know, striking one person off the list, well, no, that's probably been built in from the beginning. I'll give you an example, like, you know, if my will says I leave everything to my husband, but if my husband has predeceased, it goes down to my children. I don't have to, you know, run out and redo that when he passes away, because it's already been built in the first time that if he's not there, it goes down a level. But if there's significant stuff that's happening in our lives, well, yeah, you know, you need to properly respect that the accountant or lawyer is spending time and they're going to ask for a redo and you know, a new fee.
Okay. What happens if your loved one has passed away and you have not started the taxes or notified anybody regarding the death for estate purposes for longer than 6 months? Are there penalties? So I guess what are sort of the deadlines involved?
Yeah, the good news is, like, when you pass away in the year, and then it's to say, let's just say, you know, oh, poor husband, I'm killing him off. It's my responsibility. The tax return's not due until the later of 2 days. So the first one is just the April 30th the next year. So we may not even be in that yet at the 6-month point. And if it's between November and April, you get the later of 6 months and the later of the year. So I have one, someone passed away in February. We didn't have to do the 2021 return by April 30th. Like, we didn't have a 2-month window. We were given at least 6 months from February till August to at least clean up the 2021, and then we'll be on side to file the 2022. So the 6 months may be okay. I'd say, you know, if that's where you're sitting, it's time to really get the right professionals in place now to help you. It's time to go, you know, buy some time, sit down with an accountant, at least as a minimum, sit down with the accountant, get out there with the lawyer to discuss what's in the will and understand what's going to happen with the filings in the estate. But don't panic, you're okay for the 6 months.
Can a will be used to communicate wishes about children seeing my side of the family at a certain frequency after my death?
Children seeing my side of that. Oh, I'm not 100% sure if I've got this one, but if it's the type of thing where it's not financial related, you're imposing conditions like that, I don't believe that would be allowed in a will. I'm sure, I mean, your experiences have been either, but
yeah, I haven't seen that in a will. It could certainly be stated, but you know, Karen, as you said, I don't know if it would be something that would be enforceable.
There are letters of wishes. Now, that's not an enforceable document, but it is a document people can put with their wills. And it may say, it's my wish that after, you know, after my death, you know, the grandparents still have access to see the kids. Okay, well, you know, at least that would start the process going. It's a matter for the lawyers to address, but there's very little leeway like that that's given. I mean, I remember a really famous court case where a person had said, you know, I leave this to my son, but if he marries so-and-so of a particular faith, then he doesn't get his inheritance. Yeah. And he took it to court, and the court said that's correct. I mean, you cannot impose that kind of condition on it. So I'd be really surprised that this would be allowed either.
Thank you. If a US beneficiary inherits part of the sale of a house, are they subject to US or Canadian tax? So US beneficiary, Canadian house sale.
Yeah, Canadian house sale. Happens a lot. Let's start there. Okay, so fortunately, the first part is if, the parent will have passed away. And we'd look to see if the house is eligible for the principal residence exception. So that's the first step. So it may be that any capital gain from the time they bought the house until that deemed sale at the time of death is a gain, but it's all sheltered by the principal residence exception. So that's good news. And that works on both sides of the border. And then from that value to the sale, real estate has been going crazy in lots of parts of the country, but it's settling down. Only that spread between what was the value at time of death and what's the value when it's sold is potentially a capital gain. However, when you take off costs of the commissions and maybe things you had to do to fix it up for a sale, I often find we're into a capital loss. So it's not a problem there. We won't have tax in the estate. And the US side doesn't touch it while it's in the estate either. So it's pretty common that we don't have a problem related to anything with the house sale. We do have, what's really annoying, we do have some potential special forms that have to be filed if the house value is more than 50% of all the estate assets. And so, I'd have to talk to somebody. So it's too much to get into in this seminar, but it's just a warning that if you end up where the real estate's more than 50% of the estate value, there are extra special forms the American has to file.
Okay. What is the best way to cut taxes on inherited properties?
First, what to remember is that, the deemed disposition is how the taxes work on death. So the person has a deemed sale of everything they're holding at the time of death, except for things that are going to their spouse or common law spouse. That's both are the same now in the Tax Act. That's just considered pushed aside. And then when the survivor dies, we're dealing with this. So first and foremost, there's no inheritance tax in Canada. There's no estate tax per se. We have this deemed capital gains tax on death. So the person that's getting them, it's already been paid, say, by mom, dad, spouse, whatever. Other assets like your TFSAs and RSPs can also do this, we call just rollover to a survivor, other than a spouse. Is a problem, spouse not a problem. So the key part is looking at, for the person who's planning for the potential death, how are they going to deal with the capital gains tax on death? One of the best ways actually is through the charitable gifts. It really can. It's not going to completely offset the capital gains tax on death, but trust me, you sort of you do the calculation and say, oh, the slice the CRA is taking is 25%. And let's make a certain charitable gift, and maybe the CRA's portion is down to 3%. And guess what? The rest goes to charities. How do you feel about that? Because then you sort of look at it differently, like that piece was going away anyway. So that is one of the most effective ways. Above and beyond, I'm so pro Wellspring, of course, but I'm telling you, that is one of the most effective ways to do it.
Thank you. Okay, if I want to leave half of my home to my kids, what are the tax implications to my kids and spouse?
All right. With similar thought here, I mean, you're now giving the house to the kids, so I'm not sure where the spouse is living after that, that part of it, but.
So let's say so let's assume they're all living there, but ownership interest is half kids, half spouse.
Yeah, on the first death, the part that's going as half to spouse, we know can just go as a non-taxable event, a rollover. at the cost of the property. The half going to kids is the part that would be taxable because there's no rollover there. But we look again, is there a principal residence exemption that would at least cover the first death that's happening? But you do have to realize at that point, the kids now have half of that property and probably their own property. And you're only allowed to have one principal residence exemption. So it may not be a great move because from that day forward, they can only shelter one property from capital gains tax. I typically say it's more beneficial, unless there's some family dynamics at play here. Leave the whole thing to the husband or wife, right? The surviving husband or wife. Nice rollover on death. And then when they die, all the growth up to that point is sheltered by the principal residence exemption. And then it goes to the kids at that part. So I know that the challenge is they probably set up the joint ownership thinking probate. And I would probably, like I said before, I would rather go for the principal residence exemption, saving up to 27% capital gains tax versus probate tax at 1.5%. So here's one of those situations that, unless there's other dynamics, unless there's a need to make sure the house goes to the kids or there's a dynamic with the kids, you're not in a great tax position while you're doing.
Okay, thank you. And related just on the point of what you said, with, joint ownership, I know that some people, to avoid probate, will open a bank account or switch their bank account over to being joint with a child. Is that a good tactic in terms of avoiding probate, a joint bank account?
It's been a bit of a minefield over the last 7 or 8 years too. I mean, it's really, really common, last minute people putting things as a joint ownership or at a point where a parent can do it. The question has been, and it's been litigated a few times recently, is did the parent mean for that property to truly be the child's, and sorry, we call it property, that cash, that bank account, did they mean from that day forward that the one child on the bank account means that they gave them half the money? Like let's just keep it really simple as one child. That one view is that on that day there was a gift of half the money, which is fine. It's say it's just cash, it's half the money. And when that person, mom or dad, dies, that child takes it away. I mean, it was their gift on the account and they're meant to take 100% when they go. Or was it that, well, no, they were being put on there for this probate planning with the understanding that it was quote unquote avoid probate fees, but really it was money for everybody, all the siblings in the estate. So there was a case that had litigated this, and the key was whether the child could establish that a gift had been made. And if the child couldn't establish that they were receiving 100% gift, yes, it was supposed to fall back to the estate. So if you wanted to be the child, you actually have to draft up something to say, no, I want you to have this half of the account and ultimately the whole account. Well, guess what happens? If it falls back in the estate, you cannot argue that it was outside of probate fees. So you can't have both. You can't be claiming on the one hand, oh yeah, it's joint with the child and missing probate. And then, oh yeah, it's the estates. So you've got to be clean on what you're doing there.
Wow. Okay. And then the last one, is there a typical or ballpark percentage that goes to CRA of most people's estates?
That's a good question. If I've planned it, damn it, they're not getting that much. It really depends. If there is a large RSP, that's brutal because people, contributed a lot of their life and then didn't get to see a number of retirement years, let's say. I mean, that's the magic of an RSP. You're supposed to put it in during your working years, get good tax deductions, and then take it out as a pension in effect during your retirement years. And what if you don't live as long as you expected? Whoomp, in comes that RSP And if it's more than a couple 100,000, I mean, which does add up, some people have that, you know, you're at a 53% tax whack right there. So that is a tough one, you know, that's a tough one. People could leave that RSP to charity, at least to offset that. It's a different way to deal with it if they or leave some smaller parts of it. They don't leave the whole thing. They don't have to do the whole thing. That's a way to cut it down. And the other parts are, yeah, if there are a number of real estate properties, sure, the principal residence is one of them, but what about the cottage? What about a foreign property? Could be a lot of tax there too. So right now the capital gains tax maximum is 27%, just under. We are nervous that one of these budgets is going to jump that as well. It's all over the map, and the people I deal with, some of them, it's not that bad for the tax on death. It really depends what they have and the magnitude of what they have. But yeah, out of all the different personal returns I do, the deceased returns, you know, can have quite a lot more tax paid, quite a lot more.
Yeah. Thank you, Karen. That seems to be, I'm just going to check one more time, seem to be all the questions. So certainly a complicated area. Thank you for taking the questions. And certainly, you know, it just highlights the importance of speaking to an advisor about this type of thing, because everybody's circumstances are so very different. So if there are no more questions, again, Karen, thank you so much for your time today. Such an important topic. You know, something just popped in. Just thanking you for a very informative webinar. So thank you from all of us. Much appreciated. So very helpful.
Oh, you're very welcome. Lovely to do this.